So, hello. It's nice to interact with you again. During this presentation, we want to continue the discussion on duty of care by looking at some special duty of care situations, the application of duty of care to some special situations. Again, my name is Professor Oluwakemi Adekile, and I teach law in the Faculty of Law, University of Lagos. Duty of care. We have laid the foundation in the previous presentation of what we mean by duty of care. And we have talked about the neighborhood principle. But today we want to look at application of duty of care to some special cases. And in this presentation, I'll be addressing the question of duty of care to situations of failure to act. Liability for affirmative action. Does it exist where you do not do anything? Can the law say you ought to have done something? And so the whole essence of this presentation is therefore to familiarize you with the general position of the law and the exception to the law. I'll proceed by sharing my screen. Okay, here we have. So I hope you can see my screen. Like I said earlier, at the end of this presentation, you would know what is the general position of the law regarding a duty of care with regards to where someone fails to act. And you would appreciate the difference between what we call an act in this context and an omission to act, and know how to apply the exceptions to the general rule regarding the duty in affirmative action. Now, when you talk about liability for omission to act, we are talking about situations in which defendant does not take any positive act, does not do anything positively, and a damage has occurred. And we talk about it in terms of affirmative action. If, for instance, a man is standing by the roadside and he sees some little children trying to cross the road who cannot cross the road competently, and it does not assist them to cross the road, and they cross the road and they are hit by a car, can the law hold that man responsible for the injury to these children? Does he have a duty to assist them, for instance, to cross the road? If a man is standing by the beach and watches another person drowning, does he have a duty to rescue that person? If he does not rescue the person, can he be liable in law? Now, the general position of the common law is that there is no general duty to act, to rescue, in the absence of a special relationship. If you recall, the neighbor principle, as noted, as stated by Lord Aitken, says you owe a duty of care to your neighbor. And in that conceptualization of duty of care, we use the case of Donegal and Stevenson. And in that case, when he was trying to conceptualize the neighborhood principle, he tried to conceptualize this in terms of looking at the story of the Good Samaritan in the Bible. He illustrated with the concept that, okay, the priest passed by the injured traveler. He did not assist him. The Levite passed by the injured traveler, did not assist. These are people that are supposed to be religious people until the Samaritan passed by, who is supposed to be, they are supposed to be at enmity with each other with the Jews. And that was the person who assisted the injured traveler. Now, when you look at that storyline, there was an omission on the part of the priest and the Levite to act. Common, ordinary rules of morality will make us judge the priest and the Levite. But Lord Aitken, in conceptualizing the neighborhood principle, said the answer to that question, who is my neighbor, is those people that can be affected by my acts and omissions. And then he defined that neighborhood in that context. Those who are so closely and directly affected by my acts and omissions. That responsibility, that expectation that the priest and the Levite should have acted may make them accountable in the courts of heaven. But in the courts of in the English courts, in the courts of man, in the common law courts, they have no duty to assist the injured traveler. They have no duty. They did not cause the injury, the accident, so they have no duty. There is no relationship between them. And so what this Good Samaritan did, he did out of his own sense of conviction. So that essentially is what we are talking about. Where you therefore have not done anything positively, but you just stood by and did nothing. The law, the common law is not ready to hold you accountable, to compel you to act. So, as one judge said, the rule that I must not injure my neighbor in legal translation means I must not hurt my neighbor. I must not do something positively against my neighbor. That's a misfeasance. It's not that I am required to save him. I'm not required to save him. I should not, make any effort to save him. That's non-feasance. So we are talking about omission, pure act of omission. There is no legal liability with regards to that. But there are liabilities attendant omission in the course of a positive duty. If someone is driving a vehicle on the road and he sees the traffic light, I'm sure on the streets of Lagos, Nigeria, for instance, you see commercial bus drivers running the traffic light. When they run the traffic light, what they've done is that they've omitted, they failed to stop when they're supposed to stop. And if there is an incident, that is not an omission. That's an omission in the course of a positive duty. There will be liability for that. But failing to do anything, just standing by, and like Lord Kate had mentioned in the case of Yuen and Kunyen against Attorney General Wong Kong, there's no liability on the part of someone who stands by and watches another walk off the cliff with the head in the air, so to say. So the general rule, therefore, is that there's no duty to take positive steps to act. And this is called affirmative action. And the explanation has been given in Home Office and Docetiac, where Lord Diplock mentioned and said that very parable of the Good Samaritan that we talked about, that Lord Aitken evoked in Donegal and Stevenson, illustrates in the conduct of the priest and the Levite who passed by on the other side is an omission, which was likely to have as its reasonable consequence damage to the health of the victim of the thieves, but for which the priest and the Levite would have incurred no civil liability in English law. And another case, Lord Windsor said that common law does not require a man to act as the Samaritan did. That is the general rule. So this general rule implies two things in law. There is no general duty to rescue someone under the common law. And secondly, there is no duty to prevent others from causing damage to third parties. The reason for this are many. And one author has said, oh, it's an infringement on your autonomy to say you are compelled to act when you have no positive obligation to do so. You have that liberty to decide what you want to do and what you don't want to do. And therefore, individual choices ought to be respected. So there are many reasons in favor of not imposing a positive duty or affirmative action on others, and there are arguments in support of it. In the case of Smith and Littlewood's organization, the exceptions to this general rule were noted. In the case of Smith against Littlewood's organization, Lord Gough was able to articulate some of the situations in which English law would allow a duty of affirmative action, impose an obligation in law on you to act. And the first one is where there is a special relationship between the claimant and the person who failed to act, where there is a special relationship. It may be a relationship born out of contract, fiduciary relationship. For example, in the case of Stansby against Strowman, the the claimant had left the house for the defendant to decorate. The defendant went out for lunch and did not lock up the house, in which interval the thieves broke in and they stole some items. And the court held that decorator had a duty to the plaintiff, to the claimant, because there is a relationship of contract between them. You can contrast with Michael and Chief Constable of South Wales, where the court held that the police who refused to respond to a 911 call against, did not hold a duty of care to the victim who was subsequently killed because after that call. So you can contrast the basis of that decision. Another situation is where there's a special relationship between the defendant and a third party, between the defendant and a third party, and that third party is the one that now causes the injury to the claimant. An example is Home Office and Joseph Yard, where the Home Office, which were in charge of a postal institution, the guards of the Home Office were careless in the way they kept those boys in the postal home, and those boys were able to escape. And when they escaped, they caused some damage to the property of the claimant. And the court held that there was a special relationship between the Home Office. They had a duty to keep the boys in proper custody. And when their staff failed to do that, any damage that was caused by their omission to do what they're supposed to do would make them hold the claimant a duty of care. The law regarding liability for omissions also recognizes an exception where a defendant was negligent in creating a source of danger, which a third party interferes with and causes injury or damage to the claimant. So, but as a way of illustration, we can take the case of Haynes and Howard. The defendants had left their horses unattended on a public street. On that street where a lot of people, was a busy street, and it even had children. And the claimant, a police officer in a police station on that street, was in the office when a child threw a stone at the horses. The horses bolted and were running through that busy street. And the claiming police officer ran out of the station to try and attempt a rescue, and he was injured in the process. So the fact that they created a source of danger by their omission to keep their horses attended to made them liable in law to this claimant. The defendants would also be liable for failing to act where he had knowledge that a third party or the nature was creating a danger on his property, and he failed to take reasonable steps to abate it. Note that I said he had knowledge. He knew that some third parties or the act of nature, act of God, was creating danger on his property, and he failed to abate it, maybe abate a nuisance, and to take reasonable steps to abate it. If that takes place, then there will be liability for failing to act. And the cases that we have, Goldman and Hargrave, it's symbolic in that respect, and Smith against Littlewood's organization. That Smith against Littlewood's organization, where some of these principles have been articulated for us to have a clear view of the law, related to a situation in which the defendants had bought a piece of property, a rundown property, and which they intended to renovate and put into use. Just after they bought the property, some miscreants started making use of that property and creating fire. And one day, they ignited a fire which burnt up the property of the neighboring property owner. And then when that property was burnt down, he sued the defendants for failing to keep their property in a proper state, devoid of being used for the by the miscreants. And the court held that since they were not aware and it was not reported to them that the miscreants had been using that property and were creating a source of a danger, a risk to others, there is no way they owe a duty of care to the claimant. And that was a case where they said, okay, there was no duty of care. You can contrast it with other cases like Goodman and Hargrave and Leakey against National Trust for places of historic interest. In those other cases, liability was premised on whether there was knowledge that there is a source of danger that is being created. If there is no such knowledge, then there may be no duty of care for omission. Now, in the context of this presentation, therefore, the general rule that there is no duty of care for omissions, pure omissions that is failing to act, is that it boils down to two things. First, that there is no duty to rescue. You have no duty to rescue anybody that is in danger, unless there is a special relationship between you and the victim. If, for instance, you have you are trying to you are the one that is a parent with regards to a child. Of course, you have a relationship between you that you should protect that child. If you are a teacher that is in custody of children, you have a duty to watch those children. Those are some of the things that these cases that we're talking about. So if you fail to take proper custody of those children, there is a liability on your part. If you are the one that is in charge of take some children for swimming, or some people for swimming, for instance, then you have entered into a contractual relationship with them or any other kind of relationship. You have a duty to protect them. But if I, for instance, you are just standing by, assuming that you are at a beach or something, and you know how to swim, so you hold the world record for swimming, and you are there, and someone is begins to drown, you have a right not to take any steps. Yes, the world may condemn you and say, oh, morality may condemn you. But as long as there is no special relationship, you do not create danger, you do not assume responsibility in any way, you may not have any obligation to act. But assuming that when that child or that person is drowning, there are lifeguards that have been contracted to rescue people there and they fail to act, then that's when you begin to talk about omission being, creating a cause of action in law. So there's no duty to rescue, and there's no duty to prevent others from causing harm. Those are the two premises on which we base the implication of duty, a legal duty, a legal liberty not to act. If you are attempting a rescue, therefore, recall that we say you have no duty to rescue. The law expects that if you are attempting a rescue, then the question arises, if the rescuer also becomes injured in the course of the rescue, is the primary tortfeasor still liable to the rescuer? For instance, the man that stands by the roadside and he sees an accident occurring and tries to assist the victims. If he gets injured in the course of the rescue, can we say that it is reasonably foreseeable? No, that is our yardstick that we started using, that you would be injured. While you are driving the vehicle, yes, it may not be reasonably foreseeable that a man that is sitting in his home watching television while you are driving on the road may be affected by what I'm doing on the road. So if you want to apply reasonable foreseeability on its own, you might say it might not be foreseeable. But the law believes that it is reasonably foreseeable that if you do not drive well and you cause an accident, some people will come to the rescue. On that premise, you are liable also to the injured rescuer, because as one law has said, a cry for distress is a summons for relief. When somebody makes a distress call, it is a summons for relief. And the act of the rescuer is a product of the occasion, is a product of the incident that has called for a rescue. Therefore, a duty of care will be owed to that rescuer. And the law expects, of course, that rescuers must act reasonably in attempting his rescue. You don't make the person that you are trying to rescue worse off that they would have been without a rescue. And you also don't attempt a rescue full-hearted, in a very foolish or unreasonable manner. If you do not know how to swim, for instance, you don't know how to swim, and then someone is drowning, we don't expect that you jump into the sea and begin to attempt a rescue. So with regards to a duty of care regarding affirmative action, that is omission to act, we have emphasized the fact that there is what is called the positive act and the omission, pure act of omission, not omission in the course of a positive act. If I fail, for instance, to match my brake as I drive my vehicle onto the road, that is omission in the course of a positive act of driving. The law will not separate that failure to match the brake and stuff from the positive act of driving. That is not the omission we are talking about. We are talking about failing to do anything whatsoever, not doing, just standing by and watching someone, for instance, fall off the cliff when you have no relationship with them. There is no general duty to do anything in this context, but there are exceptions that are recognized by law. Most of these exceptions are premised on either there is a relationship between the claimant and the defendant, or with the claimant and a third party, or there is an assumption of responsibility on the part of the person. And in the light of that, that just gives us general understanding of duty of care in regards to omissions in the tort of negligence. In the next presentation, we'll be looking at the duty of care with regards to negligent misstatements under the law.